Good afternoon, or I guess morning for most of you, and welcome to our seventh in our health subrogation webinar series, Navigating No-Fault Benefits. We're going to begin by going over a short overview of why you should be making sure that you're leaving no stone unturned with regard to no-fault benefits, and then addressing a few specifically problematic states. Nancy's going to be talking to us about Florida. I'm going to be discussing a little bit about New York and New Jersey, and Stephen Smith is joining us today to talk about the Michigan no-fault scheme. So if you could turn to the first slide. What are no-fault benefits? These are benefits that are available to cover specific types of claims, almost always medical bills, sometimes some additional coverage, regardless of who's at fault for the accident. This is a first-party type coverage. It's not a liability claim. They're covering individual medical bills, and it's typically available on a first-come, first-served basis, which is one of the biggest reasons why it's important for you as a health subrogation professional to make sure that you're flagging the potential involvement of no fault early and making sure that that coverage exhausts either by payment to your client or payment of existing and outstanding medical bills. The benefits are typically going to be involved on your insured's own policy, but that's not always going to be the case. For example, if they are a passenger or a pedestrian in a motor vehicle accident, you might be looking to either the driver's policy, regardless of whether or not that driver was at fault. Additionally, no-fault benefits don't only come up in the context of auto claims. Property damage claims, particularly at commercial establishments, will often have some form of MedPay available in order to compensate a person who's injured at that facility. And so you should always be asking whether or not that coverage is available. Even if it's only $2,500, $5,000, that can make a difference, especially on smaller claims or especially on heavily disputed claims where there may be a concern about causation or overall liability limits where every dollar is really going to count. Next slide, please. So no-fault benefits is kind of an overarching term that we use to describe what's usually formally referred to as either MedPay or medical payments coverage, or PIP, which is personal injury protection. It's common in many states for individuals, especially with auto policies, to be offered both forms of coverage. And so you may have a situation where both forms of coverage are available on a single policy, and that's something that you want to ask about when you're working on coordination and reimbursement from those policies. The primary difference between those two types of policies are that MedPay will usually only cover actual medical bills, whereas PIP may have broader applications. It'll often cover funeral benefits, things associated with medical treatment, like either travel or perhaps over-the-counter medications, or devices that an individual needs that might not be covered under a health plan or a more traditional MedPay policy. And the biggest issue that often comes up in PIP claims is that it will also cover lost wages. Neither of these kinds of coverage will cover non-economic damages like pain and suffering. We are still talking about hard costs when we're talking about these types of coverage. Next slide, please. So the health plans that you're working with have a couple of different options when it comes to how to handle coordination with no-fault benefits. They can either, if their language permits it, obviously, issue a denial pending the receipt of an exhaust ledger. So if we know there's $5,000 in coverage, they want to see a ledger that says $5,000 was paid to this facility or these facilities on this date to cover these claims. The other option is that the health plan can do what's called pay and chase. And so even though they know it's an automobile accident, they process all those claims immediately and they worry about whether or not there's other coverage, be it liability or no fault coverage, after the fact and after the file is maybe referred to a subrogation specialist. Next slide, please. So both of these matters of handling claims are going to present challenges for a subrogation specialist, and potentially for the plan, obviously. If you're going to move forward with a denial pending documentation, there can be a concern about loss of discounts with providers depending on how long it takes to process those claims. In cases where there are more extensive no-fault benefits, this doesn't necessarily come up as much if the policy is maybe only $1,000, but there may be overall higher liens against liability settlements because not all MedPay and PIP policies will pay out at a fee schedule or a discounted rate. Many of them will simply issue payment for the billed amount, and so the plan may have been able to get a more favorable rate had it taken the pay and pursue method rather than the denial pending documentation method. You also run into a lot of issues just with member challenges. So the member is upset that their bills aren't being paid, they're frustrated that essentially they may be getting collection notices literally because they have too much insurance and the insurers need to coordinate with each other. And so that can be really frustrating on their end and hard for them to understand. Additionally, I've seen tons of cases where a participant, especially if they also have a liability claim, gets counsel involved, and counsel writes to the PIP or MedPay carrier and says, look, my client's grievously injured, he's going to be out of work for ages, send me the PIP money, don't send it to providers and don't send it to the health plan to coordinate. And so how do you address situations where you do receive a letter from maybe the PIP or MedPay carrier that says, look, our coverage is exhausted, we don't have any more funds to give you, but then the attorney says, well, I want to hold this money and allow my client to use it for their out-of-pocket expenses. That's, I think, even one of the more generous situations I've had. You also obviously get cases where maybe the member gets a check directly, even if they don't have counsel, and they just think it's theirs to spend, it's related to the accident. They may not actually understand what that underlying coverage is and that those funds have to be used for specific purposes. And so even if the plan is willing to work with a participant and maybe take in documentation, what are your lost wages to date? What are your out-of-pocket expenses to date? It can be challenging to get an attorney or a member to send in even the balance of those funds. And it can also create a lot of bad will if you are working on a liability claim, if you're frustrating those people that you need to work with throughout the course of the claim early on these MedPay and PIP issues, is that really is souring that relationship early on over what may be $2,500 in coverage worthwhile if these are people that you're going to have to work with on a six-figure recovery once there's some sort of liability settlement. Next slide, please. So similarly, there are plenty of concerns if the plan doesn't choose to deny those claims and just does pay and chase. As much as the member might be happier, particularly in states, and this is the converse of the concerns that I was talking about in the last slide, in states with higher PIP or MedPay, or just in cases that involve higher PIP or MedPay, recouping those benefits can present their own challenges. So first off, does plan language give you a direct right to receive money from the PIP or MedPay carrier, or once they become aware of bills, are they going to pay providers directly and you're going to have to chase the providers? Are they going to issue payments to the member directly? All of those things that are items that you should be, addressing as robustly as you can in your language, but there's not always something that you can do if an adjuster is really dead set on not issuing payment to you directly. The other challenge that we often see, again, primarily in states that have much higher no-fault limits, regards conflicting language. So obviously, we've all dealt with plenty of self-funded ERISA plans that have all that excess insurance language We're secondary to literally every form of coverage, no matter what. So what happens if the auto carrier also has that language? And so this has actually come up in the state that Steve's going to be talking about later, Michigan, which historically has had very high PIP limits. They used to actually require what we called unlimited PIP, and so all the medical bills were really supposed to be paid by the PIP carrier. It's gotten a little more complicated, but obviously with such expansive limits, there was a lot of litigation over it. And so Michigan, thankfully, is located in the Sixth Circuit, and what the Sixth Circuit decided is that if both policies say that they are excess to any other coverage, because of ERISA's uniform enforcement and the purposes of ERISA, that preemption principles would apply to allow the ERISA plan's language to be enforceable over and above the language of a state automobile insurance policy. And so the Sixth Circuit said if the ERISA plan says it's secondary, that language is enforceable and the auto carrier is going to have to pay out under those circumstances. Shockingly enough, in a case also involving a Michigan PIP policy, Winstead v. Indiana, that was in the Seventh Circuit because an individual who had one of those Michigan PIP policies got into an accident across state lines. They said, look, we're not going to give preference to these ERISA plans despite preemption principles, despite the purpose of ERISA being this uniform enforcement, and we're going to say that you have to prorate benefits even with a state insurance plan. Another huge issue that we run into way more on first party claims than I tend to run into personally on liability claims is just access to bills and records. What is the information that adjuster is going to ask you for in order to actually process those claims? And so a lot of times you'll get requests, for example, for full and complete bills and records so that they can process the claims, which leads to a number of problems. One is, do you have those bills and records? Are those things that you have to request from the providers? And does the fact that they're requesting those bills and records mean that they're going to issue those payments direct to providers rather than working with you? Are they going to create that extra step? I know that a lot of clients that we work with now, paper bills and records are really a thing of the past. And we deal with a lot of clients that have electronic data streams. And so they may not have a lot of the documentation that it seems like the adjusters are asking for. One thing that I've had a lot of success with, and that you may be able to work with your plans or work with whoever is handling your data and making your claims list, is there are plenty of providers who, especially if they're paying at a fee schedule, are looking for very specific parts of the bills and records. They may not explain this well, but what they're actually looking for are what are called ICD codes and CPT codes to determine what the treatment is. And so ICD codes are essentially what went wrong. Did somebody break their arm? Do they have a brain injury, something like that? And the CPT codes are what did we do to treat that injury once it occurred? And so you want to make sure that those things match. So if somebody broke their arm, if the treatment code says we put a cast on their leg, something went wrong and that claim is going to be rejected. But what those codes do, particularly for carriers that are paying on a fee schedule, that's what actually allows them to determine what amounts they're supposed to pay out under their policy. And so I've had a lot of success if you can even just get those two codes onto your claims list. You can significantly increase your reimbursements without actually going through the trouble of getting the full HCFA forms, the full chart notes, all of that documentation that may come in an initial request. And so it's certainly worthwhile to try providing that information before you take the extra step of getting the extensive documentation that may require a lot of correspondence with providers that are just beyond what you may have in your system or what your client may have in their system. The other significant concern with pay and chase is just the timeliness of pursuit. And so there are a couple factors that go into this. Some states and some MedPay and PIP policies are going to have deadlines where they won't consider claims after, say, 45 days or 6 months. It's gonna vary pretty significantly. And so if they're going to issue denials based on those deadlines, you may lose access to funds that you would have otherwise had access to. The other big issue I'd note with timeliness of pursuit is I have dealt with so many cases that get referred to me after they've been handled either internally or with a subrogation vendor for years, and they're in a state that has a lot of automobile benefits. They're in a state like New Jersey, where you commonly have $250,000 in benefits. They're in New York, where you have 50,000. They're in Michigan, where even though the limits aren't unlimited anymore, you often still have substantial coverage. But no one has actually looked into that PIP or MedPay option because they saw at the beginning of the case that there was an active and viable liability claim. But now we've gotten to the end of the case and there's a limits issue or there's a causation issue that means that we're not going to get full reimbursement. Or it turns out that there's, 4 or 5 people who were injured in the accident that aren't on your plan, and so the limits mean that everybody is going to have to take a significant haircut. And so the lawyer is ready to settle, ready to get you your check if only you'll take a reduction, when really you could have had your whole lien satisfied years ago if you had just gone and gotten the no-fault coverage in the first place. And so making sure that you're investigating those claims early and often is what's going to help you close out your file earlier. It's going to help, obviously, your client get repaid sooner and not be out that money for the years that liability litigation might take. And that's especially helpful. A lot of the states I've mentioned, especially New York and New Jersey, are anti-subro states. And so even if you've got a self-funded ERISA plan, I think if you handle claims in those states, you know that opposing counsel is going to be extraordinarily aggressive and tell you, we want absolute proof that you're an ERISA plan. We're going to make you jump through every hoop we've got before we'll give you a penny of repayment. If you don't need to go through that and you don't need to have that fight, save the time. Go find the PIP carrier and get them to pay you. Because if you do it early, it's going to be much easier than dealing with, everybody's in a rush to get the liability claim settled. And now we have to figure out whether or not the PIP carrier is even going to pay you directly or if they're going to make you go chase providers 4 years after the claims were paid. So those are kind of the basic considerations for any state. And now we're going to turn to some of the individual trickier ones. I'm going to turn it over to Nancy to talk about Florida.
Thank you, Catherine. So let's talk about Florida. As Catherine mentioned, states have different statutes and laws on the books as to how the no fault is actually handled. And I'm sure some of us have received a letter from a plaintiff's attorney, I know I have, that say, oh, Florida's no fault state, go away, I'm closing my file, close yours, have a good day. And that's absolutely not the case. So generally, PIP is not recoverable in Florida, but wait, under the statute, if an insured is hurt in an accident, a PIP policy will automatically pay 80% of the reasonable medical and 60% of lost earnings, subject to limits and deductible, regardless of who caused the accident. So we know that much. But any injury, including non-permanent injuries, can be sued for in tort. So there are possibilities out there. So the owners of non-commercial vehicles covered by PIP have a limited immunity from third-party tort claims. In addition, PIP benefits are set off from any verdict or recovery under their statute 627.7363. But a claimant still has some recovery options, so you want to stay in touch with the claimant and operate the way that Catherine had mentioned, early, often, know who the players are, know what's possible, what you can get directly, and again, always be friendly with your claimant. They can still recover from the tortfeasor the other 20% of the past medical expenses and 40% of the lost wages. that are not recoverable under the PIP coverage. So they may also be liable for past medical expenses that exceed the statutory 10,000 PIP limit. And under certain circumstances, depending again on the circumstances, the tortfeasor can also be held liable for future medical expenses and lost wages, even if there was no finding of a permanent injury. So there are possibilities. Don't walk away so fast. Really look into the file and what might be possible. Call Matisse and Wickard and Laird, have us take a look at your file and see what we can do for you on that. So not as all lost, even though Florida is a generally no PIP recovery state. So the next
for the working with the self-funded ERISA plans, is it sometimes a little easier to work with the PIP because there's that 80-20 distinction? Do we see individuals coming to the health plan for that extra 20%?
Not generally. Most of the ERISA plans that I work with coordinate benefits with the PIP carrier right away, and then take it from there. I've not had that happen to me. Have you, Catherine? Maybe you're speaking to something that you're familiar with.
I found, especially because there's the coordination, sometimes it's actually a little easier to get notice and figure out who the involved parties are.
Right. Oh yes, definitely.
Yeah.
That is true. We have a lot of access through the claimant through the ERISA plans for sure. Often in very close contact with plan participants. So moving forward, we are also talking about MedPay and health insurance subrogation and what the possibilities are in Florida. And again, very statute driven. And if you take anything away from this webinar and you handle the state of Florida, there are two things you need to be thinking about. You need to be thinking about incoming notices that you might receive, and you want to be aware of releases that may get executed with or without your knowledge. So going over those very quickly, under the Florida statute 768, 76.6, the insured person of the claimant must send the carrier or provider of the collateral source benefits, and that would be a health plan or MedPay. And then it gets tricky, by registered or certified mail, notification of a third-party case against a tortfeasor. So if they do file suit or they're sending a demand, thinking about filing suit, they need and they will send you this notice. But you want to be careful that the notice is following all the requirements of the statute. If they have filed suit, they need to send you a copy of the complaint. And the notice must concern a statement, and there's magic language right in the statute that you will see when you get the notice, that the provider of collateral sources will waive any right to subrogation unless it provides the claimant or the claimant's attorney a statement asserting the payment of benefits and a right of subrogation within 30 days following the receipt of the claimant's notification. So you've got a 30-day deadline. You get a letter like that. Oftentimes they try to find, or personal injury attorneys will try to find an adjuster maybe on another case. They'll try to get a little bit tricky with it and send it to someone who they think will not respond.
Nancy, I'm not sure if this is the case in Florida and Michigan. It's heavily dependent on these notices, what type of benefits are being paid. In this 30-day notice, how specific do you need to be about the type of benefits, date, duration? You know, Catherine was talking before about other parties asking for medical bills and stuff like that. How robust does this 30-day notice need to be?
The notice sending it out or responding to it?
Responding to it when you get one of these in.
I think you want to be as expansive as you possibly can. I mean, take a look at your policy, what benefits might be going out, what information you already have. Pick up the phone, say exactly what are you looking for, and respond accordingly. You can't be too careful. You don't know what they're looking for. They may just have a paralegal sending out the form letter and just ticking the file that there was a response or there was not a response.
I think the same is true in Michigan.
Yep. So just be on the lookout for any notices that come early. And then
I'll notice that I've seen that a lot of, I don't know if you've seen this as well, that a lot of personal injury attorneys, when they're sending these out, will combine them for ERISA plans with a 1024 request.
Yes. That is its own flavor. And I think we talked about that in the prior seminar, but that is its own flavor of a very specific response. And a very specific request, who's making the request and exactly what are they requesting. But sure, that's always fun when you get the compound letter. So, again, we're happy to take a look at those as well and guide through, how to answer those. So going into collateral sources, that is also can be very state specific. And Florida has, and I won't list it, it's on the slide, health, sickness, income, disability, on and on and on. So that's something that you want to be aware of. I mean, take a look at the statute. We have resources that can lead you to those statutes, and make sure that you're checking all the boxes with the benefits that you're providing or could be providing. It doesn't include benefits received under Medicare or any other federal program. So, you again want to take a look at the language of the statute. They can be long, but I've sat there many a time with my photocopy of a statute with my highlighter and my underline and my circles and my arrows. That's what you have to do in order to receive a recovery.
Nancy, we do have one question on there. Keel is asking, is motorcycle coverage still elective in Florida?
I believe that it is. I have not had a motorcycle case in probably about 7 years, but I can certainly look that up and give you the definitive answer. These cases or these statutes, as we know, change sometimes when the political wind blows. Steve is going to talk all about that. So, but as far as I know, right now, it is. So moving on to slide 3 and the importance of releases, and again, staying close with your claimant. You don't want your claimant or your participant to be executing any releases that could potentially extinguish the insurer's subrogation rights. However, if the release is given without the consent of the insurer, and if the right of subrogation does exist, then those releases are breaches of both the cooperation and subrogation clauses found in virtually every insurance contract. But that's another sideshow, time and expense that you really would like to try to avoid if at all possible. However, if a party receiving a release from an insured has notice of an insurer's perfected subrogation rights when the release is obtained, such a release will not bar a subrogation action. So again, you just want to make sure, like we talk about this in ERISA all the time, focus on every case that you get as though it may be litigated, as though someone is going to be looking at your notes and documents in discovery. If you keep that in mind, document your file, remind yourself accordingly, because again, as Catherine said, sometimes these cases go on for years, and you want certain facts to be top of mind as you're navigating your way to the recovery. A subrogation claim for MedPay is no different than a claim by a person against a tortfeasor for medical expenses. So there's nothing in the Florida motor vehicle no fault law which precludes it. So you get a letter that says no fault, close your file, I'm closing mine. Not so fast. It's a trap. So Steve, the mother of all no fault states, mother and father and all family members of no fault states, is going to be talking about Michigan.
Unfortunately, we had to switch it up because I'm going to have to leave a few minutes early. So I'm actually going to jump in with New Jersey and New York before we turn it over to Steve.
My apologies.
So, no worries. So New Jersey obviously is generally an anti-subrogation state, but auto carriers are required to offer medical expense benefits of up to $250,000. Those are the coverage that is available is going to include income continuation benefits of up to $100 a month, essential service benefits of up to $12 a day, or $4,300 total, death benefits, and funeral expense benefits. So as you can see, this is a very generous coverage offering. Very few states, I think New Jersey requires that you at least offer the most coverage in terms of PIP or no fault coverage, except for Michigan. They're the second. They used to require the $250,000, but if you switch to the next slide, you'll see that in the last few years, they've gone ahead and allowed individuals to get slightly lower coverage. So now they have to offer individuals the option to reduce the medical expense benefits coverage, which is really what we're going to be most concerned with as ERISA health subrogation professionals, to $150,000, $75,000, or $15,000. And now $15,000 is obviously still fairly generous for MedPay and no fault benefits, you know, we see plenty of states that don't require it at all, or maybe only require a, you know, $1,000 or $2,500 policy. So $15,000 can make a big difference. And the other really important thing to note is that in the case of really serious injuries, the $250,000 is still going to be available, even if the individual only elected $15,000. And so if you've got a big case, if you've got, you know, particular injuries that indicate that the accident was serious in nature, that's something that you're going to want to run by legal counsel. You're going to want to run this by somebody who's really familiar with the New Jersey statutes, because you may be able to trigger up to the $250,000 in PIP coverage and get the vast majority of your benefits paid through that manner. And, you know, if it's a case that might involve a liability claim, I would recommend that you involve plaintiff's counsel in those efforts. Remind them that the more money that you get paid through PIP, the lower the lien on any third-party recovery is going to be, if you're an ERISA plan that can assert those rights. Obviously, if you're not a self-funded ERISA plan, PIP is going to be your only option, and so plaintiff's counsel may not be as helpful. But that's a fight that you want to fight and you want to win, because that's a lot of additional coverage that you could be leaving on the table if you don't know about that serious injury exception. The individuals also have an option to reduce coverage in other ways, so so what their deductible is going to be, or to exclude income continuation benefits. But the other option that individuals are going to be offered when they make their coverage that may be important to you is that they have the option to specifically have their healthcare coverage operate as primary over PIP. And so why would people do that? The most common reason is that you might be able to get a lot of coverage, but if that coverage is secondary, it's going to be so much cheaper. And so you get a reduction in premiums for what still seems like this huge amount of coverage. You know, you can check the 250, but your premium might be cut by over 50% if you say, you know, I want all this coverage, but my healthcare plan is gonna pay first. And so if you turn to the next slide, there are some fairly specific challenges with coordination, not only related to the secondary issue, but just in terms of how New Jersey pays out these benefits. So first and foremost, New Jersey does operate at a fee schedule. So this is where getting those ICD-10 codes and those CPT codes on your list are going to be important. I will note that in New Jersey, it is exceedingly common to have your PIP carrier issue payments to providers and try to make you chase those down, which can be its own headache and hassle, because the providers may only want to reimburse you the amount they got from PIP, which may be lower than what you paid even with the discounts. The other big consideration is this this secondary election issue. I'm getting ahead of myself. So if the individual has elected that their PIP coverage is going to be secondary, that's not necessarily enforceable, depending on the language of your ERISA plan. So if you have an excess provision that says we are absolutely secondary to PIP, there is hope even if the person has elected PIP under their plan. We don't have a case quite as clear as the one in Michigan, but the Third Circuit did address this issue and was exceedingly skeptical of adopting any kind of pro rata rule just because it's so unadministrable. And so they've indicated in this McGraw case that I've put a citation to in the slides that they would be inclined to allow the ERISA plan's language to control. The language that this case came from actually involved a dispute between two ERISA plans, so it didn't need to get into the preemption issue that the Michigan case did. But I think this language is really helpful and indicates that they, they quoted the auto owner's case, they, cited it approvingly, and they've specifically discussed that when you're dealing with two policies that aren't that aren't like liability policies where there are going to be these clear limits. You know, we only have $50,000 in coverage. We only have $100,000 in coverage. Pro rata isn't really a viable concept, because how do you deal with one policy like a PIP policy that has limits against what is, you know, theoretically an unlimited policy with a health plan? And that gets even more complicated if what you're thinking about is, okay, let's look at what each of these plans would have paid for an individual claim, when the PIP plan would have paid according to a fee schedule, and the health carrier might pay according to some sort of network agreement. And so we think it's likely that the ERISA plans would have a lot of success within the Third Circuit. Next slide, please. So moving on to New York. The minimum coverage requirements for PIP are $50,000, and individuals can elect an additional $25,000. I will tell you that in my experience, almost no one elects this additional coverage. It's possible, you should look into it, you should ask, but in my experience, you're usually dealing with the 50. There are a couple of really unique things about New York's requirement. So it is PIP coverage, but what they call it is basic economic loss. And so that can get a little complicated first if you're dealing with an auto accident that happened to happen in the course and scope of somebody's employment, because unlike in the vast majority of states, you don't get both PIP coverage and work comp coverage. That first $50,000 is just going to be paid by work comp. It's not going to be paid by the PIP carrier. So you don't get $100,000 in coverage if you end up in an accident in the course and scope of your employment. It's just that 50. Some of the other challenges that we see in New York are, first off, that they have really tight timelines for submission of claims. So they're expecting bills within 45 days. And so particularly in cases where you may be coming in and trying to coordinate those PIP benefits years down the line, it's very unlikely that you're going to get the PIP carrier to agree to issue those limits. The other thing that it may be helpful for you to know is that the way the no-fault scheme works, the way the New York fee schedule works for no-fault, is actually a restriction on what the providers may bill, not necessarily a limitation on what the PIP carrier has to pay out. And so there are, I will update these slides to include a link to the administrative decision, but there's actually a decision from the relevant agency in New York that says, even if the PIP coverage has exhausted, those providers are still going to be bound by those lower billing rates set forth in the fee schedule. And so they shouldn't be billing at, you know, these crazy charge master rates once there's been an automobile accident. And so that may be another opportunity for cost savings, even if the $50,000 is exhausted and even if you've got to issue those payments. And so that's it on New York and New Jersey. And so now I will turn it over to Steve for a discussion of Michigan's scheme.
Yes, thank you. As Nancy had said before, Michigan I mean, not to belittle the other states, but it's one of the most difficult statutory schemes I think you're going to run into anywhere. And it has a lot of the flavors we've talked about so far. And I think that's the overarching point of this presentation is no fault can and often is hard. You got to know what you're looking for. You got to be asking the right questions. And perhaps most importantly, you have to be asking them at the right time. You know, in any given claim, there's a handful of recovery theories, potentials, targets, all that. And if you let time go by and you're not doing the right things, those numbers go down and down and down, and so does your, you know, recovery potential and what you're ultimately going to get back on the claim. So Michigan's no different in that respect, and there is a lot going on. So I think at first it's probably best to go over, you know, some of the basic building blocks. When is it required? It's required when you own a vehicle within the state of Michigan. And when you operate a vehicle within Michigan for 30 days or more. I'm not going to go through the the statutes verbatim here. They're on the slide, and you can read them at your leisure, but that's generally it. If you own a vehicle or you operate it in Michigan for 30 days or more, you're an owner of a vehicle and you have to have no fault in place. This is where Michigan already starts to get tricky, because you think about what is an owner, and it's in the middle of the slide here. But by statute, there can be multiple owners of the same vehicle. So looking simply at title may not fit the bill. For example, under that subsection 2 of 500.3101, a person renting or having use of a motorcycle for more than 30 days is a year of it. The same is true for the next one, sub 3, someone having use or authority to use a vehicle for 30 days more under a leasing arrangement. So you can see, if you have a driver of a commercial vehicle and he's an independent owner under dispatch for another entity, you can see how there might be multiple owners very quickly of the same vehicle. And what does that invoke? That invokes the no-fault coverage attached to those owners. So these questions at the onset are important, because already we're gathering who's all out there, what policies are issued, and where can we find recovery potential. Next slide, please. And to make a tough situation even tougher, Michigan underwent a host of reforms to their no-fault system in 2019 and 2020. And as Catherine had said before, Michigan for a long time would have unlimited limits for medical coverage. So, every claim, when you talk about exposure and everything like that, it was unlimited. So it could be high depending on what's down the road as treatment-wise. That's no longer the case. You can still get unlimited coverage, but now they have a tiered system. And the different tiers depend on what goes on during the application process for the no-fault policy. For example, you can get a $50,000 limit policy, but it requires that you show an ability to collect from Medicaid. You have to be enrolled in that. And you can do a $250,000 no-fault policy too, but the kicker there is you have to have other qualified health insurance behind it. Catherine mentioned that a little bit with New Jersey, kind of the same thing. The insured has to show during the application process that there's another layer of coverage out there that's going to come first into play before the no-fault is actually an issue. So now they have this tiered system, and it's kind of changed things up a little bit, certainly. What are insureds doing? Well, the same thing Catherine said they're doing in New Jersey. For the most part, I think they're taking whichever one has the lowest premium per month and accepting that policy. So if they can show that they have this other health coverage out there, they're going to do that to get the lower premium. But what that means for us as people trying to recover on these claims is we already got information out of that. If you see, if you reach out to the no-fault carrier and they say, hey, we have 50,000 limits or 250,000 limits, if you know the scheme, they ask the right question. Oh, you issued 250, that must mean there's another qualified health plan out there. Are you talking about us, or are you talking about someone else? You can start gathering these other, who's all involved and what policies were issued. And this is important to do at the onset, because like many of the states, there are timing deadlines that start right off the bat. And you got to ask a lot of questions from a lot of different people, because as I alluded to before, there can be multiple owners. So you need to know what each and every owner selected for no-fault coverage, and if they selected, for example, the 250, what policies they're talking about to make that $250,000 limit, appropriate. Catherine, did you have something?
Yeah, so Steve, has there been any guidance in cases where there are theoretically multiple owners of the vehicle on what to do if you're dealing with maybe a pedestrian or a minor or someone that doesn't have their own no-fault coverage, about potentially stacking those limited policies? So if there are two owners, each of whom have selected the 250 option, and there's a passenger without their own policy, could they potentially collect up to 500?
Yeah, that's a great question. And I'm going to try to go fast through this, but with Michigan, I could give an hour presentation on so many nuanced issues. So I'll go quickly here, but that's a great question. First of all, with respect to stacking, if benefits are available to an individual under more than one no-fault policy, he or she is going to qualify for the policy with the highest limit. So it's going to be capped and not stacked. That said, you asked another question about a pedestrian, and that's a great one too. Where are we looking for coverage? You know, if no fault has multiple owners and they all have different policies, where do you look? This is where Michigan, again, gets very nuanced, because if you're talking about a pedestrian, the priority statutes say you look to the policy of the vehicle involved in the accident. The primer for all Michigan no fault is the accident has to involve the use, operation, or maintenance of a motor vehicle. It's that simple. So even in a pedestrian situation, that's true. There was another motor vehicle. So there you're looking to the owner of the motor vehicle, who's likely the tortfeasor. So this gets kind of weird that you're talking about the tortfeasor, but you're not talking to his carrier necessarily about his or her carrier necessarily about their liability coverage. You're talking about their first party coverage in the case of a pedestrian. And why that's important, and it's who you're looking for, and then the base question is also, are no fault benefits even appropriate? Because in Michigan, if someone is involved in a motor vehicle accident and they had a duty to procure no fault benefits, the individual that is, and they don't, they're not entitled to it from any source. What this happens with, where I see this most often, is there's multiple policies out there. The claimant has one on his personal vehicle and he owns this commercial vehicle too. It's not registered in Michigan, but it's been operated in Michigan for more than 30 days or more. And no one's actually went out and secured a no-fault policy. Well, vis-a-vis that gentleman himself, he's not going to be entitled to no-fault coverage because he didn't have the necessary security in place. So you can see at every layer here, there are a bunch of questions that need to be asked, and they need to be asked quickly. And we'll get to that in 1 second. Next slide, please, Jamie. So we talked about, I mentioned this a moment ago, we're talking about priority here, which is, it's a big part of recovery in all no-fault states, but perhaps Michigan more than anywhere else. So when can you actually not be talking about priority and be talking about subrogation? Well, the statute, it's up there. It's wordy, but when you boil it down, there's 3 situations: an accident outside of Michigan, an accident where the other vehicle is uninsured, or an intentionally caused accident. All 3 of these, 2 of them, practically speaking, for recovery potential, in my experience, kind of swallow the rule, right? Because if you have a tortfeasor that you want to pursue in subrogation and they're uninsured, well, sure, you can pursue them in tort, but you want to make sure that you're not throwing good money after bad, doing this large lawsuit for someone who at the end of the day is not going to have insurance. The second one is an intentionally caused. That's another exception. But again, if someone's, if the tort arises with a motor vehicle and it's an intentional tort, there might be coverage denials at play within the policies you're seeking. They may say, no, we don't cover intentional torts under our policy. So again, you could end up with a situation where, yeah, there's someone to pursue, but practically to what end? It does have a common fund reduction, and it only attaches to damages that were actually paid by the insured. So this is another question. The nature and extent of the injuries is important because when you talk about reimbursement and seeking recovery, the actual type of benefits paid is going to matter. And that also applies to personal property protection down there. The statute is down there as well. Pretty much reiterates the same thing we're talking about with no fault coverage. Well, I guess it is a sub-insurance type of no fault, but property and MedPay and wage loss are treated similar in this regard. Next slide, please. Now, again, I say this over and over, Michigan gets complicated because I just told you when tort is available. This 3135 is important to know, but I'll glance over it because the overarching point is that sub 3B. The claimant can obtain the injured driver or person involved in the motor vehicle accident. He or she can bring a claim for tort where the carriers cannot. And the reason why is they can bring a tort for non-economic losses and for losses above their no-fault limit. So by definition, what you can see here is that we're talking about them recovering damages for which no benefits were paid, no fault or otherwise. Because, you know, it's going to be extremely rare that a certain policy covers non-economic losses. And if we're talking about losses covered above the no fault limit, again, by definition, those are above and beyond the damages that were paid in no fault. There's also a mini tort section. This gets a lot of questions in our office, and rightfully so. Michigan does in general, but mini tort allows for recovery of the insured's deductible for property damage, collision damage for $300,000. The caveat is just like MedPay and wage loss is you have to have a no fault policy in place. If you don't, you're not going to qualify for the mini tort. You're not going to qualify for benefits, and you're not going to qualify for the immunity. So making sure that the claimant that he or she is covered by at least one policy somewhere is important to decide all these things, decide whether they can be liable in tort, to decide whether there's recovery potential from another source, a bunch of things. Next slide, please. And Catherine, oops, sorry, I didn't mean to do that. So there's 503.1351 again there. You see it out there. The important language is that last part. Only if the insured person has suffered death, serious impairment of bodily function, or permanent serious disfigurement. So here's yet another question we got to be asking. And it goes back to the type of benefits that were paid, but also the injuries that were suffered. Because for the claimant to make this claim for non-economic damages, there needs to be what's often referred to as a threshold injury, serious impairment, permanent disfigurement, or death. And I'm not going to go out over that right side. It shows the standard for showing that, but you know, a lot of these questions in no-fault states are the same. Just like Catherine was talking about, you have to have a certain type of injury. Here we're talking about the type of injury again. This is all a fact-finding mission that needs to start early. And for recovery potential to be at its best, it needs to be robust. Next slide, please. And so that covers tort. The long and short of it is, in most situations, the other driver is, the tortfeasor driver is not going to be a good candidate to seek recovery potential from. There are paths where that's not the case. There are exceptions and nuances that I just went through. For the right claim, certainly, it might be a very good path to recovery. But more often than not, in my experience, coordination is going to be the main one. So when it comes to a no-fault carrier and another insurer, and here I'm talking about a non-self-funded ERISA plan. Between the no-fault insurer and the other health insurer, the no-fault insurer's coordination clause is going to trump that of another health insurer. And that's how you get the $250,000 limits if you select that tier. So what it says in their policy, you know, the claimant has provided an application saying they have other qualified health insurance. The no-fault policy, in turn, often says that that they're going to be excess over that other health insurance. It doesn't change the other health insurance into a no-fault policy. You still keep the limits, exclusions, with one very important exception that I'll mention, and all that, and what benefits are covered, but those need to be exhausted before the no-fault policy comes into play. That's if both the no-fault and health insurer are coordinated. If the no-fault policy is not coordinated, then you're going to look to to see if the health insurer is. Most often, in my experience, that's not the case, though, because that's the whole point of them offering this $250,000, policy. And if it's a 500 or unlimited, perhaps the other health insurance isn't out there the same way it is with 250. The one exception I will note is Michigan. It often required what's called well, it still does. I guess I'm waiting for case law, but it requires what's called a pure exclusion. So a lot of policies say, the other health insurance policy or what have you says something to the effect of, our policy is excess, or we do not pay for benefits that are covered by uninsured motorists, work comp, or no fault, or similar laws, something like that. Well, what Michigan case law has said is that a policy provision like that is against the public policy of Michigan. And so what they require instead is a pure exclusion, meaning that you need something along the lines of, we do not cover motor vehicle accidents in Michigan for the exclusion to be upheld. All this to say is that if there's a battle between no-fault carrier and health insurer, and the health insurer says, wait, we have an exclusion for anything paid under no fault, that coordination clause is likely still going to trump both the health insurer's coordination clause, and that exclusion is likely going to be found insufficient to avoid that coordination. Next slide, please. I did not see if any other questions came in.
Yes, Steve, there is a question.
Oh, sorry, I'm trying to read it right now. Oh, okay, yes, that's a great question too. So I believe the question is, and please correct me if I'm wrong on here, is whether Michigan no fault is going to come into play when a parked vehicle is hit by a commercial vehicle. This is a great question because a parked vehicle, just like a pedestrian, has its own provision of no fault. And in fact, I'll give you the site right here because it's laid out. But generally, who you're going to be looking to is the commercial vehicle that hit them. There are a host of issues that are going on with parked vehicles. It's very fact intensive. It has to be reasonably parked on the roadway for for this. The general rule on coordination is a person looks to the policy under which they are a named insured. When you're talking about a parked vehicle, this is an exception to that priority rule, and you're talking about, like the pedestrian, the policy covering the vehicle involved. A parked vehicle doesn't qualify as a vehicle on the Michigan roadway, i.e. being used in the use, operation, or maintenance of a motor vehicle if it's reasonably parked. Now, what I meant before with this can get very fact intensive is exactly that. It does. You have accidents where the vehicle is parked, but people are in the process of unloading or clearing off snow off the bed of a truck, or they're repairing a tire and that falls within maintenance. And you get into a lot of these cases. Well, what if the tire's on and they were putting the jack in the back of the truck? Are they still engaged in maintenance, or is it now reasonably parked? These can get very fact intensive right at the onset. And again, this kind of harps back to the main theme, I think, of this whole thing is the right question questions early on to leave as many doors open for recovery as you can. Because the more time that goes by without knowing this information, without responding to notices, without sending out your own notices, doors are just closing. And the options for recovery, they might have been 4 to begin with, 2, 1, none, you know. Michigan has a timing requirement. That again could be a long webinar in itself, but it says that you have to provide notice of the no-fault accident within a year. And then they have a second year-long limitation period that you can only sue for benefits within 1 year of the date litigation was filed. So like a simple example, if an accident happens in January and you send your no-fault notice within 1 year in the 6th month, you don't file suit until the 18th month, you can only get benefits from month 18th to month 6th, because 12 months within the accident. And that too gets very complex, and the right people need to be on notice very early on, and the right things need to be happening. So I'll quit rambling. Nancy, do you have anything else? Are there any other questions?
Yeah, I just wanted to address the Florida motorcycle laws because it's a little bit of a tricky one. So PIP is not elective for a motorcycle rider. It's just not available at all. But you're not even required to show proof of insurance when you're registering a motorcycle. However, liability insurance and self-insurance is required if you get in an accident per the Florida Financial Responsibility Law. So if you're a motorcycle rider, 10K and BI, 20K BI per accident. I'm hearing an echo, sorry. And 10K in property. That's coming on your end?
I was just wondering if it was. I don't believe so. I'm not getting an echo, but in any event, thank you everyone for participating this afternoon. Questions, all of our information is right there. Please do not hesitate to contact us. No-fault states are difficult, and they take being through the gauntlet a few times to figure out, you know, where to be asking questions and to whom. Also, if there's any feedback on what you guys think, what you all think is important, you want to learn about, or stuff you think we could be doing better, certainly give us that. We always want to improve and give you the best product we can. So thank you again, everyone, for participating. Jamie, is there anything else we need?
Yeah, I think we want to talk about our next seminar, number 8, All Things Medicare, on September 27th, same time, 12 o'clock Eastern, 11 Central. Please join us. It will also have a lot of information. Thank you, everyone.
Thank you, everyone. Have a good rest of your day.